and get some technician to look at Lorenza Villa's firewall, which is blocking her computer. And we will go ahead with the next presentation, which is also an important issue because Brexit is round the corner. It has been round the corner now for several years, I believe 3 or 4 years, and now, at least at the end of December 2020, it probably will be the end. However, a lot of work needs to be done, and that work are issues that will be discussed in the next presentation. So, Lady Olga, please go ahead with your speak, and then after your speak, Gareth will come in. Lady Olga, please press speak. You were there before. So there you are. Yeah, you're back, lady. So please continue with your speak.
Right. Can you hear me now?
Hold on, I'm online.
Yeah, now you're on. Please go ahead.
Oh, okay.
It was a browser problem, actually.
Okay.
Whatever. Olga, for me,
Lorenza kommer på, men vi kan ikke høre, hvad hun siger.
For me to write.
Lady, please hold one moment. Lorenza, could you please speak?
Du er nødt til at trykke på den McAfee deroppe.
Can you hear me?
I can hear you.
Okay, we are just trying to test if we can hear Lorenza. Lorenza, could you please speak?
Yes, I'm here.
anything?
Can you hear me now?
No, we cannot hear you. So I
Olga
suggest
can hear me.
Lady Olga, please go ahead with your speech.
Oh,
Sorry.
okay.
Kirsty, who are you addressing?
Please go ahead with your speak, Lady Olga.
Oh, right. Okay, fine. Sorry. Can you hear me now? All right. Can you hear me all right?
Yes.
Okay. So where we are now, this is a very important year. Leaving the European Union is not going to affect just the UK, but also Europe and indeed our relationships worldwide. So we will leave on December the 31st for good or ill. Now, you could say, certainly the UK, thank God for the coronavirus as it has distracted the government and the people with due cause. But it has also thrown the Brexit debate way off the wires. And many would say no bad thing. A fatigue factor of Yahoo exchanges have not been enlightening on all parties. However, there will be a wake-up call next month in June. June will bring more tense times, angry exchanges, speeches and letters. And matters are not helped by doing it over the internet. In reality, personal contact does matter. June should be the deadline for finalizing all the details. Well, will they get there? Probably not. Will they ever get there before December the 31st, when it is all over? Well, these are very good times for the betting man. My gut instinct is that they will scramble over the line at the last minute. By then, instead of the technocrats, Barnier versus Frost, it will be the Prime Minister Boris Johnson and his opposite numbers in Europe, led by Merkel and Macron. Pragmatism finally has the last word, and it could be Merkel who brokers it. So what is the real block? Is it really the detail about fishing rights, harmonization of standards, competition, movement of people's financial services? Well, all these matters can be resolved when the political will emerges. The block today is ideological, and with it a completely fundamentally different approach to the EU-UK approach. The EU struggles with losing a major trading partner, and this has been a major blow economically and politically. And the UK has struggled to make itself heard as a sovereign country, ranking number 6 in the world's economy. Only Germany is ahead of us in Europe, but in fact, as Europe is concerned, the UK word doesn't really carry the weight that it should have done. So it therefore stands that the UK sees itself as sufficiently mature to make its own decisions and controls of laws without the diktat from Brussels. Of course, there have been many benefits to being a member of the EU, which will be sorely missed. My own view is that departure was based more on emotion than reality. Well, be that as it may, the UK is flexing itself. It has made it clear that once the bridge has been crossed by the EU and accepting our full sovereignty, things will move on. I totally accept that a free trade agreement with the UK is bound to be very different from all the other ones. For a start, over 60% of UK trade has been with the EU. This is way ahead of all their other trading partners. We're on the doorstep of the EU. We're not a faraway economy with only limited impact, such as Jordan, Lebanon, or Moldova. All told, around 60 countries or groups have free trade agreements with the EU, but they vary in their terms. And the UK agreement cannot fit into any of these categories. Hence, it has to be tailor-made for mutual benefit. At the moment, the UK is playing hardball, saying it is content to exit without any deal and operate through the World Trade Organization. Well, in my view, that's decidedly imperfect. But that is the whole process of negotiation, and in the course of it, not a pretty sight. I do not see Boris Johnson seeking an extension. That is pure wishful thinking. Looking ahead, yes, I can see a rocky path for the UK for the next 3 years. Time we can ill afford to lose after the price of the coronavirus. It can be a lonely business forging our own identity. Trade agreements with major markets are always tough. Apart from the EU, the UK is working to do the same with the US. Well, they too will play hardball, and they will try to push us hard in accessing our markets. There is little sentiment either there about the much touted special relationship with the UK. The way to survive for the UK after Brexit is to be creative and imaginative, to be the aisle everybody wants to trade with. This could happen with trade incentives, free ports, vastly reduced tariffs, and give a genuine welcome to other nations, including our friends in Europe, to come and profit from a commercial hub from which we will all benefit. Thank you. Kirsty, I'd like to hand over now to Gareth. Are you there, Gareth Garvey?
So thank you. So thank you very much, Lady Olga. It
Thank
was,
you.
as usual, a nice presentation with in-depth and with your political connections. You were also able to give us some insight and some information on what probably could happen, especially next month in June, which is a decisive month for how the rest of the negotiations with the EU will proceed. We will now continue with Gareth's slides so that we can follow up on Lady Olga's speech and Gareth's presentation. Gareth is the CEO of the British Chamber of Commerce in Denmark. And of course, he has also a lot of insight on what's going on, because the commerce component of any agreement with the EU is decisive for how things will proceed. So with that, Gareth, please go ahead.
Can you hear me okay?
I can hear you.
Super, super. Great. Kirsty, you mentioned a birthday earlier, the 2-year birthday. We've got a 4-year birthday coming up of the vote to leave the EU, and that's coming in the middle of next month, or towards the end of next month. But I'm not going to go back into history. I want to pick up from where we are at the moment. So if I could have the next slide, Christian.
So Gareth, please go ahead.
Great. So yeah, we left the UK left the EU on the 31st of January 2020 this year, and the slides have just gone back. So if you could find it again, Christian, that would be great, so people can see what I'm talking about. But when we left, we moved into the transition period, and that means that we've got until the 31st of December to get a deal on the table and to agree that deal, as Lady Olga has already mentioned. She's much closer to the politics on this. I'm giving you the sort of background and where I think we might be going. But we've got the deadline coming up at the end of June, where it's possible to extend the negotiating period by 1 or 2 years. I seriously don't believe that's going to happen. The British government have made it very clear that they don't want that extension period. I get the impression that there are certain people in the EU, particularly in the negotiating team, that would like the transition period to be extended, so the negotiations can be extended. But we are still facing the situation that we might have at the end of 2020 a no deal. It's a different sort of no deal. The no deals we were talking about before were related to the withdrawal agreement, but here we're in a situation where we could actually, the UK could leave the EU with no trade agreement in place. If I could have the next slide, please. So what's going on? Well, now the negotiations are going on within the transition period. There's a bit of negotiating and positioning going on, as Lady Olga referred to. There's some interesting characters on both teams. Michel Barnier has been there for a while, and he's been he knows the ropes. The British negotiating team is being led by David Frost. David he was at one stage the British ambassador to Denmark, so he's got a background in diplomacy. He has worked in Brussels. He speaks fluent French. That was part of his education at Oxford. So he's probably well qualified. He knows the ins and outs of Brussels. He speaks more than one language, which is, as most of you know, unusual for a Brit. Corona hasn't been helpful in this, because people are having to have these strange conversations over video links or over emails, etc. Fairly recently, there was an exchange of letters between David Frost and Michel Barnier. Frost sent a letter saying, "This is what we want to do. Here are some documents." There were 13 documents published setting out a pretty much standard trade agreement, free trade agreement. Barnier wrote back and said, "Well, we sent you something in the 18th of March. What about that? We're looking for something different. Clearly, Canada and the UK aren't the same. so the agreements can't be the same. You're right next door. You've been a major part of us. You're a competitor. So this is going to go on, and there's some, let's call it negotiating going on. At the same time as all this is going on, we've got to remember that the UK is also negotiating trade deals with the rest of the world, because it's been using the EU trade deals for the last many years. So that's another set of work that goes on, and these two things are not necessarily disconnected, so they may impact each other. Once we do get to the stage where we think we might have a deal, then there's a ratification process. So, and that's in all the EU countries as well. So we need to realize that the time between now and the 31st of December, which is 220 days, a lot's got to go on to make things work in that period. So what does this mean? Can I have the next slide, please, Christian? So the no deal is still possible. As I've already mentioned, the government does believe the deal can be put in place, and are very bullish about it. The interesting thing, if there's a deal that gets made in draft with Europe, then the Prime Minister should be able to get it through Parliament. He has a substantial majority, and so he's got the tools to get that through. There are many leaders around Europe that are skeptical about this and whether it's going to happen, and they all need to be on board with this. So that's just a little summary of the no deal possibility. Now, as Lady Olga said, we're hoping that something will happen at the last minute, and everything will fall into place, and we'll have something that we can work forward from and continue to build on, and continue to have. It's in everyone's interest that the UK and the EU continues to have a good trading relationship. It's not a total split. We're going to be working together, and everyone wants to work together. And from a business point of view, and I represent businesses, we're looking for some certainty, some clarity, so that we can get on. We've been putting plans in place. We've been looking at scenarios A, B, C, D, E, and F for the last couple of years at least, certainly the big companies. And we want to be in a position so that we can move on and get on with business and know where we stand. If I could have the next slide. So then we come down to data protection, GDPR. Within the period prior to the withdrawal agreement, prior to the 31st of January, or prior to when it was agreed, when it started, and it started on the 31st of January, end of 31st of January. The UK tried to have discussions about adequacy under Article 45, but the clear message from the EU was, we're happy to talk about it, but we're not going to talk about it yet. Now, some people describe this as another negotiating position. Others say we've got other things to do before we start talking about data protection. But during the period from now until the end of the year, it's business as usual. So we carry on going using the existing rules. But if we do get to and this is a situation we don't want, if we do get to the 31st of December this year without a deal in place, the UK becomes a third country, and Article 46 becomes relevant. If I could have the next slide, please. Will the UK be awarded adequacy? Well, there are a few. We've been working to the same rules for a while, you would say, so you could imagine that it should be fairly straightforward, and that's the British position. But the Commission does need to go through a formal assessment process. It normally takes much longer than the time we have, but you can argue that we're close together, so that's not necessarily a problem. We did incorporate the 2018 Data Protection Act within within UK law, so that covers pretty much most things. There are some issues around that, but which we can come on to. The UK as a third country could come under more scrutiny, and there could be some issues around, for example, the Investigatory Powers Act, which there have been some challenges from a human rights perspective on that. So the other interesting factor is that you don't get adequacy and keep it. It comes under review. So there's always a sort of sword of Damocles if you decide to diverge from the standards that have been agreed and seem to be adequate. And I don't think that's in anyone's interest that we diverge massively. Johnson has said that we want to do our own thing, but we do have laws in place. And let's see. If I could have the next slide, please. I'm sure you all know how adequacy is assessed, and we saw Japan go through it. We're looking at the rule of law, effective independent supervisory authorities, international commitments, and as I've already said, we're in a position, and the EU is in a position to reverse a decision. And the next slide. But I think we're pretty much close to each other in regulation at the moment. So unless there's some issues around the European Commission for Human Rights, I think that should go ahead without too many problems. There will be distractions and other trade agreements with other large countries that are wanting to have a say in these in data protection issues as well. The key is that the future relationships shouldn't be affecting the autonomy over the personal protection data rules, but the EU can withdraw the adequacy, of course, if another party drifts too far away. And how much time is there? Great, good timing. Just to finish off, if there isn't a trade deal in place, then this is an out-of-date document, but it would cover it. We would need to have other things in place, as we know, in terms of the various other processes that we typically have for countries that don't have adequacy. So there are things to do for the companies that do move data between the EU and the UK, so it's the standard stuff: data protection clauses, binding corporate rules, codes of conduct, etc., and derogations. Those I'm sure you've all been into in a lot of detail. So I will stop there. We could be in the no deal situation. We hope not, but if we are, then companies will need to do something. Thank you.
Thank you. Thank you, Gareth. It was very enlightening to hear your thoughts. And of course, there is a big deal of discussion on whether or not the adequacy rule will apply. There is a question from Lena who asked that there is an internal document that says that in the event of a no deal, or there is says that the likelihood of becoming an adequate country is small due to the surveillance access from the UK authorities are high. This is, of course, an internal document. Do you have any thoughts about it, Gareth?
I mean, it's something we've been aware of. There have been some questions around sharing of data and surveillance generally, and also sharing of data with the Five Eyes network from a security point of view, which tends to tends to fall out of the standard business world. But people, there are people that are raising issues around this. So it's likely to pop up.
Yeah, and there is also an option that there is some kind of a privacy shield that countries with excessive surveillance get. So perhaps it is a possibility that UK may get something similar. We have seen it happen before.
Yeah, we have seen it happen before, and it's. I think all options are on for the moment.
Okay. Oh, very soft. Thank you very much, Gareth. We will now try again with Lorenza Villa. So, Gareth, if you can mute yourself, and let's see whether we can speak and hear Lorenza.
Do you hear me
Lorenza,
now?
welcome. I made the introduction earlier, but I can repeat it. You are a lawyer in Bologna area in Italy. You are GDPR consultant, data privacy officer, a versatile legal expert on legal components of the European data privacy and protection landscape. And you have multiple languages that you can speak: English, French, Russian, Spanish, and of course your native Italian. So Lorenza, please go ahead.
Okay, thank you, Kelsey. Happy GDPR Day to everyone. I'm really honored to be invited here to talk to you all. And as a matter of fact, the subject matter of my speech is it's quite difficult because, in the last 2 months, we can't see the slides anymore. Okay, perfect. In the last 2 months, we had our extra bit of legislation, and as many of you may know, Italian legislation is quite crazy. We had a lot of decrees, orders, regional orders, and so on. So what happens? We had the most important legislation that we have to take into account at the moment as for GDPR, on the GDPR side, is the reopening Italian legislation. Not sure anymore. No, it's not for me, this one. It's the reopening legislation related to COVID-19, which strongly interacts with the GDPR. So to get to understand how all this works, I'll have to talk to you a bit about what is the COVID-19 related legislation. May I have the next slide, please? Okay, the main source at the moment, one is the first one is the decree of the presidents of the Presidents of the Council, 17 May 2020. Where some national and regional protocols for reopening were transposed. Next one. Next slide, please. As for 24 April 2020, we had a framework legislation, which consisted of 3 national general protocols, and one for workplaces, construction sites, and public transport. It's just a framework legislations that gave us all the requirements, or gave the businesses all the requirements for reopening. Next one. And as a matter of fact, these internal document, hold on, I'm really no, it's not for me. As a matter, next one again is we can go a bit quicker. In this decree, we had some no, I think we Oh, it's okay. Anyway, I can go. In this decree, we had also some sector-specific sheets. What I mean, with the general protocols, there were general rules for reopening. Then these rules were specified by some technical sector-specific sheets with reference to specific areas like restaurants and catering, tourism, hotel and accommodation. And always on the 17th of May, which was actually Sunday, we had some further protocols. Next slides, please. Coming from each of our regions in Italy, which are 21, if I'm not wrong, 20 or 21. We had some changes lately. Then we also have to follow some other recommended guidelines, specifically those from INAIL, which is the National Insurance Company for employees, and those from ISS, which is our National Health Institute. Next slide. And here we start to approach the GDPR issues. As we can see in the Annex 10, we can find some general principles. And if you read the last two, specific and consistent individual reopening approach, previously planned organizational measure and system solution, and a risk-based approach, this reminds us of Article 25 and Article 32. Next slide. Where the previous legislation, the COVID-19 legislation for reopening interacts with GDPR. I also taken into account the general protocol for workplaces, which is divided into 13 sections. And issues related, GDPR issues related can be found at Section 2, Section 3, and we will see why in a while. Very shortly, in this section, businesses are compelled to measure temperature at the entrance when they have to admit someone to the workplace. Next one. Again, in Section 8, Section 10, Section 12, Section 8 as for smart work, Section 10 as for the training activities and the selection of a video conference or a training platform. Again, rule Section 11 and Section 11, Section 12 are probably the most sensitive sections as to data processing, because when this is the future legislation, if an entrepreneur has a COVID-19 related case at the workplace, it has to be started a specific procedure which leads to a contact to our national health authorities to deal with this case, so that all personal sensitive data of this person has to be transferred to the competent authorities, but not also these data, but also as the data pertaining to all the strict contacts of this person. So you can now have already a quite clear view of what our legislation means when we come to data processing. Next slide. The legislation, the COVID legislation, wants the employer to draft some intervention operative plan. It is not said that this plan should be in writing, but as a matter of fact, as you may already have understood, it's always here is again a matter of accountability, and the focus is on the individual protection of the employee or of anyone who is working in a firm. Plus, the operative plan, in my opinion, has to be in writing, because there is another problem. In Italy, it has been said that a COVID infection is now a work accident, which, on the basis of our legislation, may lead to an employer's civil or criminal liability when he has a COVID case infection at the workplace. It is a hot topic at the moment. It hasn't been solved yet, but the principle should be that if the employer can give evidence of his or her compliance to protocols, guidelines, and best practice, we shouldn't be able to talk about his civil or criminal liability. Next slide, and we come directly to the GDPR issues. We had a lot of support from our supervising authority, and we had many guidelines on employers' self-certification requests before admittance to workplaces and data collection, of course, serological tests at the workplace. Then we had a very interesting document, which are the facts for employers, which gives an overview of all the GDPR-related issues for compliance. There was another document about privacy and training platforms and privacy and smart work. As we may be very happy with our supervising authority, because they supported us very much in this period. Privacy is also taken into account in the general protocol for workplaces in the section 2, although there are some I wouldn't say mistakes, but there were some elements to be changed, as for the legal basis, for example, or the retention period. But it was really appreciated, the fact that they put some reference to the GDPR in that document. Next slide. So what data we may process dealing with all the COVID-19 legislation? For sure, as I was telling you before, temperature data coming from temperature measuring, and it will be before admittance. It's temperature measuring is not compulsory for workplaces, but would be compulsory, for example, in the protocol for construction sites. It is compulsory, on the contrary, to take the temperature when we have infection cases, at the workplace. Then there would be another bit of privacy issues in the interactions between the employer and what we called, and I don't know if in your countries you have a similar professional, but in Italy we have the so-called occupational physician, which is a physician which interacts on a regular basis with the employer. And of course, he has to be defined as a processor. He, according to this legislation, he has to inform the employer about any situation of risk or fragility or previous illness of an employee. And our supervising authorities pointed out that this is okay, but the occupational physician would never mention the specific illness or disease. This means that when we have to, that one of the main tasks of a data protection officer, or anyway an employer, is to revise the data protection agreement, giving specific instruction to the physician. Next slide. Again, there will be a lot of interactions between the employer and the health authorities, both in the COVID-19 case management, sorry for the S, and as for all the procedure of cooperation in identifying the strict contacts chain of an individual after a COVID-19 case at the workplace. What does it mean? If we have a COVID-19 case at the workplace, we shall cooperate with the health authorities in identifying all the contacts of this person during the 14th previous days, so that all the most proper hygienic measures can be taken. First of all, another quarantine, another isolation at home for 14 days for each of these persons. Other issues, as I told you, are training and video conference and data processing and smart work. Next slide, please. So this slide comes, it's a summary of which could be all the compliant accomplishment under this COVID legislation. First of all, the employer should, or the controller should draft privacy statements for staff and general public. The processing purposes are mainly set out by the law and could be temperature measuring, admittance procedures, COVID-19 related case management, cooperation with the health authorities. Legal basis, in my opinion, many legal bases should be considered, and I refer to those from Lecture B, G, H, I, and F, Article 9, Paragraph 2 of the GDPR, although in the general protocol of for workplaces, less legal bases are taken into account, but I would advise my client to stay on the safe side, as we all know. And this comes from the fact of our supervising authorities, specific measures of confidentialities, as no disclosure at all by dissemination in the workplace, because this would be the main problem. I mean, it's, of course, it's a workplace, people know each other, but when you have a COVID case in the workplace, you should do the most and take appropriate measures to insulate the person and not talk about this event with the other employees. No disclosure for staff, limited disclosure to any third party. Data retention, it is said that it should be enough to put until the end of the state of emergency. I would say at least, because there must be, it depends on the legal basis you take. Of course, if you want also to take the legal base of defense of the processor, this should be, the term of data retention should be put off a bit. It depends actually on the decision of the controller. Then there must be instruction to processors under Article 29 GDPR as called temperature measuring, COVID-19 case management, cooperation with health authorities, and as I said before, instruction to the occupational physician. Next slide. All the issues GDPR related as smart work and privacy and video conferencing. Next slide. And here we come to sanctions and inspection bodies, which is quite peculiar and may expose the controller both to sanctions under COVID legislation and GDPR. Why? First of all, non-compliance with protocols means suspension of the activities until achievement of compliance. And among the inspection bodies and authorities, there is Guardia di Finanza, which happens to be the main inspection body as for GDPR compliance. So it is clear that at this point that when we draft an operative plan, it should be advisable to deal also with privacy issues, just to stay on the safe side. And I don't think I have any more slides. Yes, that's question and answer. That's all. I hope I've been clear enough. I understand it's quite a puzzle, but I'm always available to ask to your answer to your question. Sorry.
Thank you very much, Lorenza. Extremely interesting, extremely detailed, and extremely nice. It is not only valid in Italy, but it is valid on almost all over the world, especially in Europe. Yes. I have a couple of questions, but we will wait for the questions until we have the panel discussion. So all speakers, stay online, don't go away. And Lady Olga, could you please introduce the next speaker?